Hello again. Hello, it's me, Patrick John McGinley, your friendly neighborhood bar grievance defense attorney, proudly defending my fellow members of the Florida Bar or District of Columbia Bar against bar grievances, ethics complaints, and other ethics-based investigations. Today, we're here, as always, continuing our discussion of the ABA's model rules of professional conduct that you need to know and you need to understand, not only as a lawyer, but as a potential person who will take and pass the MPRE, Multi-State Professional Responsibility Examination. Today is lesson 10 in our series. Today's focus is upon advertising, specifically the lawyer and the law firm advertising legal services to the public. In our studies of advertising, we're going to be looking specifically at Chapter 7 of the ABA's Model Rules of Professional Conduct. So we will cover all of Rule 7.1, 7.2, 7.3, 7.4, and 7.5, but with a specific emphasis upon advertising. We're going to have a separate lesson after this one. It'll be Lesson 11, where we'll have a greater focus upon solicitation. Today, we will touch upon, but not exhaust, the topic of solicitation under the Model Rules of Professional Conduct. Today, our particular focus is upon advertising. But in order to reach that focus, we do have to address some definitions. We do have to understand what is considered advertising under the Model Rules of Professional Conduct, and what is considered solicitation under the Model Rules of Professional Conduct. The reason we need to understand the difference between the two is there are specific rules that apply to solicitation that don't apply to advertising, and some specifics of advertising that don't apply to solicitation. There is, however, Rule 7.1. 7.1 applies to all communications, whether those communications are deemed to be advertising or not, and whether those communications are deemed to be solicitation or not. Either way, Rule 7.1 applies to that communication. So, before we go to the next task of defining what's advertising and what's solicitation, let's first look at Rule 7.1 because it applies to advertising. It applies to solicitation. It applies to both. Model Rule 7.1 says that either one, advertising or solicitation, either type of communication concerning a lawyer's services has to be something that is not false, has to be something that is not misleading. When is a communication concerning a lawyer's services false? When is it misleading? It is false or misleading if it is a material misrepresentation or omission. A material misrepresentation or omission. When is it a material misrepresentation or omission? It is a material misrepresentation or omission when it lacks a reasonable, factual foundation. So there, my friends, is what we're talking about when we talk about the requirements of Rule 7.1. 7.1 says our communications, whether they're labeled as advertising, whether they're labeled as solicitation, any and all of those communications concerning a lawyer's services, they all have to be true. They can be neither false nor misleading. The test to determine whether they're false or misleading is whether there's a material misrepresentation or omission. And the test for determining whether there's a material misrepresentation or omission is whether or not there's a reasonable factual foundation. If it lacks a reasonable factual foundation, then it fails the test, and it is false or misleading. Make sense? That's what Model Rule 7.1 requires. And that's required regardless of whether It's advertising regardless of whether it's solicitation. That requires to every communication concerning a lawyer's services. For example, and this is an example given previously, but it's relevant here. Again, a lawyer can't state or even imply that the lawyer has the ability to have an improper or undue influence upon a tribunal or an entity that is adjudicating a claim or controversy. If so, that would be false or misleading. That would be a material misrepresentation. That would be a violation of more than one rule, including but not limited to 7.1 and Model Rule 8.4. So there's an example of a violation, a communication that would be false or misleading. Obviously, as lawyers, our word is our bond, and it should be a statement that can be trusted. And that's true even when we're communicating concerning our services. That's the point that Model Rule 8.1 is trying to drive home. With that overall requirement, not to be false or misleading, that applies to both advertisements and solicitations. We have additional rules that apply to advertising and additional rules that apply to solicitations. On the other hand, let's look first at advertising. What is it? What is the definition of advertising? I would give this definition because this definition I've coined for you is entirely consistent with the model rules, their stated definition, and their intent. Advertising is the broad dissemination offering legal representation. Any lawyer communication concerning a lawyer's services that takes the form of a broad dissemination offering legal representation meets the definition of advertising that we find under the model rules of professional conduct. So there, in my opinion, is a usable and accurate definition of advertising that can help you get the right answer when it comes to the MPRE. Here's a working definition, wholly consistent with the definition we find in the model rules and in the commentary to the model rules. For solicitation, what is a solicitation under the model rules? A solicitation is a communication concerning a lawyer's services to a specific potential client regarding that potential client's known or suspected, tripped over my own words, that potential client's known or suspected specific legal need. Since I tripped over my own words, let me try that one more time. The perfect, in my opinion, definition of solicitation that is wholly consistent with the definition in the model rules and in the commentary there too, is a communication concerning a lawyer's services to a specific potential client regarding that potential client's known or suspected specific legal need. So let's compare and contrast the two definitions, shall we? Notice in the definition of advertising, we are talking about the general public because we're talking about a broad dissemination. Compare that to solicitation, where we're talking about a specific potential client and that potential client's known or suspected specific legal need. That's how we draw the line between an advertisement and a solicitation. Now, in a typical case, it can be quite obvious as to whether we're talking about an advertisement or a solicitation. For example, if you were to open the Yellow Pages and see a printed ad, obviously that's an advertisement. Obviously, that's a broad dissemination offering legal representation to anyone who might open the Yellow Pages. Likewise, if you were to visit a website, that too would be advertising because that is a broad dissemination offering legal representation to anyone who might visit the site. So in very many instances, It's obvious whether it meets the definition of advertising. Likewise, in very many instances, it's obvious that it meets the definition of solicitation because it's not a broad dissemination. It's a specific potential client who's hearing from the lawyer about that potential client's known or suspected specific legal need. For example, there is an automobile accident, and the lawyer, being the Good Samaritan, stops her car and helps the injured driver. I'm thankful for your help. I would return the favor to you anytime, says the driver. Now's the perfect time, says the lawyer, because I'm a personal injury lawyer. Here's my business card. Please call me. Let's see what we can do about getting you an adequate recovery for this particular wreck that we're all here standing in. That is the quintessential definition of an example of a solicitation. It's also a violation of the model rules as given in this hypothetical. It's also something that would subject that hypothetical lawyer to discipline under the model rules of professional conduct. So a solicitation is often one-on-one. A solicitation is often face-to-face, but a solicitation need not be face-to-face. For example, direct mail can leave the definition of advertising and become a solicitation. When the letter is written to a specific potential client regarding that potential client's known or suspected specific legal need. Compare these two examples of direct advertising via mail. On the one hand, imagine that a lawyer has an office in a specific zip code and offers wills, trusts, and estate planning services. That lawyer might draft a letter, which is pre-approved by the bar that regulates that lawyer and complies with the typeface, statements, font size, colors of ink, and all the other various jurisdictions requirements, and then sends that letter to everyone in that specific zip code. That's advertising. Compare that direct mail to the criminal defense lawyer who buys the list of arrests from last night's jail in his or her zip code. And with that list in hand of names and addresses, sends the same letter to those clients offering to be their criminal defense attorney. That meets the definition of a solicitation. So it's not necessarily the media that determines whether it's an advertisement or a solicitation. Rather, it's the comparison of broad dissemination versus specific potential client. When the communication concerning the lawyer's services is specific to a potential client regarding that potential client's known or suspected legal need, that meets the definition of solicitation. So when it comes to solicitation, I have a separate lesson prepared for you. Today's lesson instead focuses upon advertisements and advertising. Focuses upon communications concerning a lawyer's services of which there's a broad dissemination offering legal representation. So let's talk about advertising for the rest of this particular lesson. With a view now toward advertising, let's return to Rule 7.1. 7.1 covers things including advertising. And it talks about how an advertisement has to truly and truthfully talk about a lawyer's credentials or achievements on behalf of clients and can't be misleading and can't be false when it makes those reports and descriptions. Now, with an appropriate disclaimer added, an advertisement can be transformed from false or misleading into something that's not a material misrepresentation or omission. Disclaimers are routinely required by regulations and by the bar when potential advertising is submitted to the regulators or the bar for their pre-approval. Now, I can speak to the model rules of professional conduct, I can speak to the rules regulating the Florida bar, and I can speak to the DC bar rules of professional conduct quite well because I'm a member of Florida and DC. I can't speak to every jurisdiction everywhere, but it's quite clear in the jurisdiction of Florida that there is a prior restraint upon the commercial speech of lawyers imposed by the rules regulating the Florida bar in its Chapter 4-7, where it talks about the regulation of advertising. With very few exceptions, an advertisement has to be filed and the payment of a filing fee has to be made to the Florida bar prior to the lawyer running that advertisement. And I know what you're thinking. This has constitutional law implications. Of course it does. We are lawyers, but we are also citizens. And despite the fact that we're the members of an organized bar, we remain protected by freedom of speech and the First Amendment to the U.S. Constitution. Are there times where it seems that regulators such as the Florida bar forget that truth? Yeah, it certainly seems that way to me and to others, including federal judges. I want to take a moment to talk about federal precedent, such as the case of Christian Searcy et al. Versus the Florida bar, a decision from the United States District Court for the Northern District of Florida, which talks directly about the constitutional issues of freedom of speech for a lawyer and the regulation by the Florida bar. Now, this decision came out not all that long ago, depending on your perspective. I'll be quoting from the September 30th, 2015 order on the merits in this particular case. This involved a law firm that presented a First Amendment challenge to two Florida bar rules that govern attorney websites. Is a website advertising? Yes, we already answered that question. It certainly meets the definition of broad dissemination, offering legal services. So the rules regulating the Florida bar, just like the model rules of professional conduct, regulate a lawyer's speech made on the website. So here in Searcy versus Florida bar, two rules of the Florida bar were challenged. Court notes that the first challenge rule, at least as interpreted by the bar's Standing Committee on Advertising, requires any statement on an attorney's website to be objectively verifiable. And as I talk to you today, almost 5 years after the issuance of this opinion, it remains true that the rules regulating the Florida bar require any statement on an attorney's website to be objectively verifiable. The opinion goes on to note that the Florida Bar Standing Committee on Advertising says a website, therefore, cannot include a statement such as, quote, tort reform benefits insurers, end quote. The rule, as so interpreted, would obviously violate the First Amendment, says the United States District Court for the Northern District of Florida. See it right there. Would obviously violate the First Amendment. But in this lawsuit, the bar renounced any such interpretation. That was awfully honorable of y'all. Of course, you had to be taken to court before you renounced it, but thanks. Thanks for acknowledging that even though I joined your bar, I still have some rights under the U.S. Constitution. Thank you. Thanks so much. The bar has not, however, renounced application of the rule to at least some truthful statements about an attorney's past results. Wow, what were these outrageous, truthful statements about past results? Well, here's one. Tell me what you think. Tell me if this is something that should be forbidden. The law firm said the following on its website, quote, 32 years of experience handling mass tort cases resulting in justice for clients in a wide variety of circumstances, end quote. So the law firm alleged that it had, quote, 32 years of experience handling mass tort cases resulting in justice for clients in a wide variety of circumstances, end quote. Why did the Florida bar want the firm to take that statement off of its website, remove it from its website advertising? Was it not true that the firm had 32 years of experience handling mass tort cases? Yes. Yes, it was true. Florida bar agreed. The firm argued and proved, and the bar did not dispute that the firm had 32 years of experience handling mass tort cases. Did that 32 years of experience result in justice for clients in a wide variety of circumstances? Yes. Yes, it did. The firm was able to prove, or you might say objectively verify, that to be true. Why then was the Florida bar saying that had to come down from the website? Here's what the opinion explains. The theory of the Florida bar was that, quote, justice, quote, and, quote, successfully, quote, are not objectively verifiable. I don't know about you, but I like to think as a lawyer, one of my goals is justice. I don't know who you've talked to who's a member of a bar, but I often hear other members of the bar saying that they work within the system of justice, that they're a member of the justice system, and that part of their job is to try to achieve justice. Under Florida bar's interpretation, where justice can't be objectively verified, no lawyer should claim to be working for justice, according to the Florida bar's interpretation of the phrase objectively verifiable, at least until this opinion reminded the Florida bar that that's a clear and obvious violation of the First Amendment rights of Florida lawyers. Also, the word successfully. Lawyer can't use that. Does sometimes a lawyer have a goal given to the lawyer by the client that the lawyer then achieves? Yes. Would any reasonable human being label that as success? Yes. Would Webster's dictionary and any other dictionary of the English language published by any other publisher state that that meets the definition of successful? Yes. But the Florida bar says success is not something that can be objectively verified. And that was the Florida bar's position until the United States District Court reminded the Florida bar that that is a clear and obvious violation of the First Amendment to the United States Constitution. You can't interpret objectively verifiable to omit things that are neither false nor misleading and have proof. One of the reasons you can't do that is the First Amendment. So prior to this opinion, quote, the bar has not renounced these positions, quote, and had to be ordered to renounce them. So what was the outcome of this case? The outcome was that the rules regulating the Florida bar, as interpreted in that way, were unconstitutional. Were there any other interpretations pursuant to this opinion that were found to be unconstitutional? Absolutely. Can a lawyer call her or himself a specialist? Before this opinion, the Florida bar said no. Nobody calls himself a specialist, says the Florida bar, unless we, the Florida bar, certifies them under our board certification program. At the time, there are only approximately 23 areas of the law where the Florida bar even offered an exam and a certification process in order to obtain board certification. Are there more than 23 areas of the law? Yes. Those 23 or so areas of the law that existed back then were not so broad as to encompass any and every area of the law. They weren't even so broad as to encompass the vast majority of areas of the law. It was only a small minority of areas of the law for which one could even ask for board certification from the Florida bar. But regardless of how expert you were, regardless of how much experience you had, regardless of how much success you'd achieved in your particular area of the law, unless it was one of the 23 areas, you couldn't call yourself a specialist or an expert. And unless you met all the requirements, including passing the exam for that particular area, still you couldn't call yourself a specialist or an expert. For example, say you had practiced for just 6 years in appellate law and had done just 27 appeals in those 6 years. But you'd also applied for and satisfied all the requirements for board certification in appellate practice, including passing the exam. That's the hypothetical description of hypothetical lawyer A. Compare that to lawyer B. Lawyer B has 30 years of experience in appeals, not just 6. Lawyer B has prosecuted 700 appeals, not just 26. Lawyer B is renowned throughout the community for success as an appellate lawyer, whereas lawyer A is not. Under the Florida bar's interpretation before it was struck down as unconstitutional in this case, only lawyer A could claim to be an expert specialist in appellate practice. Lawyer B could not. Another harsh example. Imagine your area of practice didn't happen to offer a board certification exam. Imagine, for example, that you are a friendly neighborhood bar grievance defense attorney like yours truly. There is no board certification for friendly neighborhood bar grievance defense attorneys. There's not even board certification for unfriendly neighborhood bar grievance defense attorneys. No bar grievance certification whatsoever. But what if that's your specialty? And what if your local community, or maybe even the legal community at large, considers you to be an expert? Prior to this decision, the Florida bar would say, can't call yourself an expert, can't call yourself a specialist. Is that an obvious violation of the First Amendment, like the court held right there? Yes. Yes, it's an obvious violation. So why do I keep harping on this particular case? As we study the requirements of advertising, both under the model rules and the Florida bar rules, some of these things just might not seem right to you. Don't fall for the fact that just because they've been put in either a model rule or a bar's rule, that they have to be constitutional. Until this decision, many things that were unconstitutional were being routinely enforced. Don't forget that even though you're a member of the bar, you're still a citizen of the United States. You're still protected by the U.S. Constitution, even if the particular bar of which you're forced to be a member somehow forgot about the Constitution. So let's take a look at the model rules, but let's not forget the constitutional issues that they give rise to. Let's take a look at Rule 7.2. And Model Rule 7.2 is specifically called advertising, so we can state with confidence that it applies to all advertising. And don't forget the definition of advertising that I've given you. It is a statement concerning a lawyer's service with a broad dissemination offering legal representation. So, can a lawyer advertise? Long, long ago in a galaxy far, far away, that answer might have been no. But many generations before you and I became lawyers, the United States Supreme Court held that lawyer advertising is commercial speech and therefore protected by the First Amendment, and therefore there can't be an outright ban. No bar can say no advertising by lawyers. So there must be advertising permitted, but that advertising can be regulated as commercial speech. And that's one of the things that Model Rule 7.2 does. It regulates it. One of the regulations under Model Rule 7.2b talks about what you can pay in return for a case. And that rule says nothing of value. Can't give anything of value in return for somebody recommending you to be the lawyer. Are there exceptions? Yes. And those exceptions are quite narrow. Remember that we can't, as lawyers, share attorney fees with a non-lawyer. So there is such a thing as a referral fee. But that referral fee can never be paid to a non-lawyer. Can be paid to a fellow member of your bar as a referral fee by meeting your bar's specific requirements for a referral fee, which would include knowledge to the client and informed consent of the sharing of the fee. Now, with that in mind, you might think, hey, I think I see a problem here with Model Rule 7.2 because nobody prints an ad for free, whether it's Google AdWords running your ad or a Bing search engine or DuckDuckGo. Does that still exist? I think it does. Or the local newspaper. Do those still exist? Depends on where you live, I guess. Or a national newspaper, or television or cable TV or internet television advertising. No matter where the ad runs, the purveyor of your ad is going to want some money, right? So does that run afoul of these rules to pay the purveyor of the advertisement their fee for running the ad? And Rule 7.2 sub B tells us no, both under 7.2 sub B1 and 7.2 sub B2. 7.2 sub B1 says it's okay to pay the publisher. And I mean that both in a digital sense and in a physical sense, whether it's the website that hosts your ad, the search engine that presents your ad, or the OTA television provider that's broadcasting your ad. In a digital sense of publisher, it's okay to pay for the advertising. The same is true in the physical sense of a publisher. If you're in one of those rare locales that still has a local newspaper or a national newspaper or a magazine or whatever kind of physical publication we're talking about, you can pay the purveyor of the ad in order to run your ad. That's permitted by 7.2 sub B sub 1. And also note 7.2 sub B sub 2 allows you to pay the approved lawyer referral service. Now, that's not a broad definition. That's not broadly defined. In order to be an approved lawyer referral service, you've got to meet the requirements of the particular bar we're talking about. So if we're talking about the Florida bar, there are some detailed requirements for an entity to become an approved lawyer referral service. There's also, under the rules regulating the Florida bar, a specific definition of what constitutes a lawyer referral service. So if the particular entity meets that definition, you can't deal with it unless it has been approved by the Florida bar, because you running your ad with an entity that meets the Florida bar's definition of lawyer referral service will be a violation of the rules regulating the Florida bar if that entity hasn't been approved as a lawyer referral service by the Florida bar. Are there issues here under the First Amendment, such as freedom of speech, freedom of association? Oh, yeah, they are. But these are how the rules read and are being enforced as I speak to you today in the month of June in the year 2020. So you can write a check to either a publisher or an approved lawyer referral service and not run afoul of fee sharing rules and not run afoul of the rules regulating advertising, such as Model Rule 7.2. Another example is if you're buying a firm. If you're buying a firm and you follow the requirements of Model Rule 1.17, then that payment, even if it includes the firm's website, the firm's existing advertising contracts, and other communications concerning a lawyer's services that you buy as part of that purchase, that's not a violation of Model Rule 7.2. That's okay, because it meets an exception under 7.2 sub B sub 3. Another exception we want to talk about is Model Rule 7.2 sub B sub 4. That's an exception for the reciprocal referral agreement. What is it that I mean when I talk about the reciprocal referral agreement? I'm talking about how it's defined in the Model Rules of Professional Conduct. And there we're talking about an agreement that the client knows about. They're informed about it. They know that it exists and they know its nature. And it's not an exclusive agreement between you and the other lawyer or non-lawyer. Interesting, right? Non-lawyers included. So as long as it's not exclusive, you can, but you aren't required to make the referral. And in return, you get no money back. But you get the potential of another referral back that the other entity, lawyer or non-lawyer, can, but isn't required to give to you. And the clients know about this. That's what I'm talking about with a reciprocal referral agreement. What's a clear instance of something that's not meeting the definition of reciprocal referral agreement? When there's money changing hands. So if there's money changing hands, that's not meeting the definition of reciprocal referral agreement. And if there's money changing hands, it better not involve a non-lawyer, because remember, the model rules don't allow us to share fees with non-lawyers. That's true also of the rules regulating the Florida bar. So the reciprocal referral agreement might involve the non-lawyer, but that's okay because the reciprocal referral agreement never involves money going back and forth. It just involves referrals going back and forth. That the clients know about, the existence and nature of that agreement, and that is not exclusive. So you can, but aren't required to send the referral. In return, for the receiver of that referral, might, but isn't required to send one back. That's the reciprocal referral agreement that meets the exception of 7.2 sub B sub 4. Now, Here's the final requirement that you see in Model Rule 7.2, and it's important when it comes to advertising. It's certainly part of all advertising under the rules regulating the Florida Bar and the DC Rules of Professional Conduct. And there is this, what I'd like to call the sign it requirement. Sign it. What I mean by that is the lawyer advertising has to give the name and the office location of at least one of the lawyers who's getting the work from that advertising. Somebody's got to, if you will, sign it. So you got to have a real name of a real lawyer and a real office location. Can't be a virtual office. Can't be a P.O. box. Can't be some shared desk in somebody else's office that the lawyer stops by, even on a routine basis. It's got to be a physical, bona fide office of that lawyer. So that's the requirement of 7.2 sub C. And that is a fair summary of the requirements of Rule 7.2. Now, let me illustrate some important things that we've learned from reviewing the requirements of 7.2. Can the lawyer get some help with advertising? Yes. Obviously, we already mentioned that they can hire the publisher, whether that's the website hosting or the website search engine. But what about a publicist? Can a lawyer hire a publicist? Yes, that's permitted. Maybe even PR personnel. How about a marketing firm? Yes, that's permitted. Remember, however, those entities, as they do their work, must comply with all rules regulating the Florida Bar. The lawyer has a duty of supervision, and the lawyer has vicarious liability for any violations of the rules regulating the Florida Bar committed by that publicist, PR personnel, or advertising agency. It's not a defense to say, oh, I didn't personally draft the ad. The ad agency did. No. Likewise, in those states, Florida being one of them, that has a prior restraint upon our free speech and requires the ad to be filed and a filing fee paid to the Florida Bar prior to its running, it's no defense to say the ad agency didn't know about that. Believe it or not, there are individuals that might have a lot of marketing experience, but limited or no experience working for a lawyer. They might have some great advertising skills and knowledge of what works for non-lawyers that simply can't be implemented for a lawyer or a law firm because they run afoul of the advertising restrictions and the rules regulating the Florida Bar. So my advice is, if you're going to hire an ad agency, hire one that has experience working for lawyers. They need to learn that. Why should they learn it on your dime and with your risk that they're going to run afoul of rules they didn't know about? It's hard enough to supervise and manage others. Why hire an ad agency that you have to supervise and manage and become vicariously liable for that doesn't know what it's doing when it comes to lawyer advertising? A bad idea, in my opinion. But opinions are like noses. Everybody has one. Maybe you want to be the person who helps an ad agency learn how to do lawyer ads. More power to you. But remember the risk that you are assuming on that. Here's another thing that we learned by reviewing the requirements of Rule 7.2. What about pay-per-click? Pay-per-click. Are you familiar with it? Whether it's Google AdWords or Bing or DuckDuckGo or any other internet search engine, you might want to come up first when someone searches for a lawyer in your area and needing your area of expertise. You might do that through Organic means is the term that internet advertisers often use, by which I mean you might show up on the first page of the Google search simply because your website is good enough to meet whatever algorithm criteria the search engine is using. But another way to get yourself on the first page is to pay to be there through one of these pay-per-click systems. There, you can buy the right to show up at the top of the page, and depending on the particular search engine, all you might get is as little as one bolded line and maybe 2 or 3 other lines below it, maybe even a small graphic to accompany your bolded line and your other 3 lines. For those of you who remember newspapers, and the younger ones out there, you can look this up in the history books. But the newspapers used to have something called the classified ad. The pay-per-click ads at the top of the search engine, I think, try to mimic that because there are very few words in there. Might be as simple as, law office of Patrick John McGinley, PA at the top, and then in the next unbolded lines, defending fellow Florida lawyers against bar grievances and ethics complaints. That little snippet, that little pay-per-click at the top of the search engine, does that meet the definition of advertising? Well, remember the working definition I gave you. It's a communication concerning a lawyer's services broadly disseminated offering legal representation. So yeah, despite this very small size of the pay-per-click snippet, it meets the definition of advertising. So in Florida, before I run the snippet, do I have to give that sentence, those 40 words or less, to the Florida bar and pay them the $150 filing fee and get their pre-approval? Yes. Yes, you do. Is there an exception under the rules regulating the Florida bar? Well, there is, and it's a limited and narrow one. There is a short list in the rules regulating the Florida bar as to what you can say. And if you say nothing but the things on the short list, then despite the fact that your snippet meets the definition of advertising, you don't have to pay the filing fee. You don't have to subject yourself to that prior restraint upon free speech that is required by the rules regulating the Florida bar for any statement that meets the definition of advertising but contains something that's not on the very short list. What's on the very short list? Your name, your law firm's name, its address, its phone number, its website, your email address, the area in which you practice geographically, the area in which you practice when it comes to substantive law, in other words, the type of law you practice. And then a couple other words that are enumerated that you might call salutations, such as best wishes or serving the community or happy holidays. The list is that short and that specific. And if you keep to just those things, then you don't have to pay the filing fee and file in advance before running it. But the point is, the takeaway is, both under the rules regulating the Florida bar and the model rules of professional conduct, despite the very short nature of either a classified ad or a pay-per-click snippet, that's advertising, and that's subject to regulation. Let's look at another example of something we learned by studying Rules 7.1 and 7.2. What if you're on social media? Pick your social media. LinkedIn, Facebook, Twitter, Instagram, many others, whichever. What if you're on social media and you make a statement? Because you're a member of the Florida bar, does that mean your statement is advertising? No, but it might be. When is your statement on social media advertising? when it meets that definition, when it's a broad dissemination offering legal representation. Whenever you make a statement on social media as a member of the bar that meets the definition of a broad dissemination offering legal representation, that's advertising that is subject to the requirements. So some of your Facebook news feed, some of your LinkedIn posts, some of your Instagram shares, some of your tweets on Twitter are advertising. You need to know before you hit post whether it was. Because if you hit post and it was, you may have violated the rules. So watch out. Does that mean a lawyer can't enjoy social media? That's not what it means. But it does require caution when dealing with posts on social media. Let's take a look at Rule 7.3. 7.3 talks about solicitation. It is going to be, as I mentioned, the topic of its own lecture. For now, the thing to remember is, what is solicitation? Solicitation is a communication regarding a lawyer's services to a specific potential client regarding that potential client's known or suspected specific legal need. Any communication that meets that requirement is going to also need to meet the requirements of Rule 7.3. More to come in the next lesson. Now let's turn to Rule 7.4. 7.4 talks about communicating about the lawyer's specialization or the lawyer's fields of practice. And this model rule almost reads like, and I apologize in advance to the drafters of the model rule, it almost reads like a list of insults to lawyers who really treasure their rights of freedom of speech under the First Amendment. Because it makes some ludicrous statements that should be obvious to any government regulator. A list of statements that should be obvious that lawyers can do without having some rule spelling out that it can be done. A says we can talk about the specific fields that we practice in. Wow, thanks. How nice of you to allow me as a lawyer who doesn't want to be the jack of all trades and master of none to instead tell the world, don't bother calling me unless you do need a lawyer who does X, Y, or Z, A, B, and C. Hey, if you can't think of the lawyer and the lawyer's rights under the First Amendment, can you at least think of the needs of the public? How many times should a member of the public who needs a lawyer to write a will have to call a personal injury lawyer and be told, sorry, we don't write wills? Call a criminal defense lawyer and be told, sorry, we don't write wills. Call a civil litigator and be told, sorry, we don't write wills. Call an administrative law specialist and be told, sorry, we don't write wills. Call an appellate practice specialist and be told, sorry, we don't have wills. Wouldn't it be nice if the public could look and see whether the lawyer writes wills before they call? So, bar regulators, if you don't care about us lawyers and our rights under the First Amendment, can you at least please care about the public? Can you at least please care about consumers? Can you at least please care about potential clients? This 7.4 sub A reminds bar regulators to please care about the public and the First Amendment rights of lawyers, because it says we're allowed to state what areas of law we practice and which ones we don't. Rule 7.4 sub B says that patent attorneys are allowed to call themselves patent attorneys. Hey, thanks. It's so nice of you. Rule 7.4 sub C says if you practice admiralty, you could say that you practice admiralty. Oh, wow, that's so nice. Rule D says you can't say you're certified as a specialist unless you've received certification as a specialist from an approved authority that your bar approves as being adequate to certify specialists. I don't know why we need that, because didn't 7.1 already tell us that it can't be false or misleading? To say that you're certified by XYZ group when you're not would clearly be false or misleading. I guess if this particular rule offers any help, it helps to identify the fact that you can't just get certification from anything or anyone. Imagine, if you will, somebody puts up a website and for $50, they'll sell you a certificate that says you're certified by them. Wouldn't help the public much for lawyers to be buying those $50 certificates when the only requirement for being certified by that group was to write them a check for $50. It helps the public, however, when organized groups do more than just write a certificate, when they actually have a reliable program for inquiring into the reputation, skills, and experience and knowledge of the lawyer who's applying for certification. And hopefully is diligent and accurate about who they award certification to and who they don't. So that's what this rule is trying to talk about. It's trying to weed out and prevent these websites. You might call them a diploma mill. You might call them by other derogatory names, where you just write a check and in return you get an alleged certification. We don't want lawyers advertising those kind of diploma mill or worthless certifications. And that's what this model rule talks about. Now let's focus on Rule 7.5 when it comes to firm names and letterhead. Just like 7.1 reminded us, firm names and letterheads can't be false or misleading. But hey, how could the firm's name or the letterhead be false or misleading? Rule 7.5 helps us understand that. For example, subsection A would make it a violation to imply that you're somehow part of or connected with either the government, be it the federal government, the state government, or a governmental agency or a governmental unit. So you can't have a name that is false or misleading with that regard. Also under Rule 7.5, talks about public office. So if somebody holds a public office, their name shouldn't be in the law firm's name if the lawyer isn't also practicing law with the firm, which for most public office holders isn't really possible. Imagine you're the President of the United States and you happen to have a law degree. You're probably kind of busy being the leader of the free world, probably too busy to take on a personal injury case on the side. So even if you happen to be a named partner in a law firm, once you're elected President of the United States, Rule 7.5, subsection C, is going to require the firm to take your name off the name of the firm, at least until you're ready to take that personal injury case on the side. Now, on the flip side, imagine a state senator or a state representative who's in the state House of Representatives or the state Senate. And in some states, that may truly be a part-time job. So while the state Senate or the state House of Representatives is in session, regular session, busy session, the firm shouldn't be advertising that name as part of the firm, but Thereafter, assuming the special session or no session doesn't distract that particular member of the firm from taking on cases, then it would be appropriate to have that person back in the advertising for the firm. What about a retired this or a retired that? Maybe you've met a retired judge, a retired senator, retired person who retired from public office. Yeah, their name can be on the firm. You should indicate, however, if you indicate their old office, you must indicate their retired status. So maybe you got Sally Salison. I made up a name. And Sally Salison used to be the governor of the state. And now Sally Salison is back in private practice. You might refer to her as just Sally Salison or Mrs. Sally Salison. Or you might refer to her as Governor Sally Salison retired in the firm's advertising. But if you're going to use governor, you got to use retired. That's a requirement of Rule 8.4 and a requirement of Rule 7.5 of the Model Rules of Professional Conduct. Same thing with retired judge. I see more and more retired judges love to become mediators. I guess in their heart, they're neutrals, huh? So I see very often, I'm going to mediate with Judge so-and-so, spoken between lawyers. But when Judge so-and-so is no longer judge, instead is a mediator, they should be clear on their advertising that they are Judge so-and-so retired. Retired Judge so-and-so is how the advertising should read. And that's a requirement of Rule 8.4, a requirement of Rule 7.1 to not be false and misleading, and a requirement of Rule 7.5 that talks about firm names and letterheads. A trade name. Can a law firm use a trade name? The answer is yes, if it's not false or misleading. One of the ways you can always avoid advertising being false or misleading under Rule 7.1 is to use disclaimer language. And that remains true to avoid a false or misleading name under Rule 7.5. It's quite common to see law firms called the such and such law firm, and then underneath the name it says a private law firm. That disclaimer, a private law firm, can help avoid a trade name being false or misleading. Now remember, there was a United States Supreme Court case that held that legislation can prohibit the use of trade names in professional practice. But under the Model Rules of Professional Conduct, trade names are not prohibited as long as the trade name is not false or misleading. What about a lawyer passes away, a lawyer dies? Can the dead lawyer remain on the letterhead? We sometimes see letterhead that lists all the lawyers in the firm. If on that list is a lawyer who died, must I take the name off the list? Not necessarily, but to avoid the list being false or misleading, you do have to indicate that that lawyer is deceased. So you might add the word deceased in parentheses after her or his name. Or if that seems crass, you might open a paren, put the year of birth, a dash, and the year of death. So 1943-2020, for example. That too would indicate that the lawyer is deceased. But in order to avoid the firm's letterhead that lists the name of a dead lawyer from being false or misleading, you're going to have to somehow indicate that that person isn't available to take cases because of that person passing away. How about this? What if the lawyer who passed away was a named partner? Must I now rename the firm because that partner has passed away? The answer is not necessarily, because there's another option. One option is to rename the firm. The other option is to clarify to the public that that named partner has deceased. So maybe you're the law firm of Orlando and Knightley, and you've been around for 112 years or something. But Orlando and Knightley have both passed away. Can you go on in year 113, 114, 115 after the passing of Orlando and Knightley and continue to call yourselves Orlando and Knightley? Yes. At that point, that's a trade name, right? Because neither of those lawyers is alive. But to make sure that trade name is neither false nor misleading, you're also going to have to include the disclaimer that both Orlando and Knightley have passed. And you might do that in a less crass way than putting deceased in the name of your firm. You might instead include a list of lawyers in your letterhead and note the year of birth and the year of passing for both Mrs. Orlando and Miss Knightley. So it's possible for a firm to live on after the named partners have passed away, with proper disclaimers and properly indicating the passing, so that the trade name is neither false nor misleading. Here's a tough one. What if one of the named partners in the firm is disbarred? So you've got firm of X, Y, and Z. Y was subject to discipline, found guilty, and is disbarred. Can the other lawyers continue to practice calling themselves the law firm of X, Y, and Z? And the answer is no. Because you could only have lawyers named if you're going to name your firm based on named partners or named members. Anytime there's names in a law firm's name, those individuals have to be licensed to practice law. So if one of them gets disbarred, then their name comes off the name of the firm, comes off the letterhead, comes off the sign on the door, comes off all the advertising. Can this get expensive for the remaining lawyers? It can, and it must, because they must change the name of the firm. What about a less severe discipline than disbarment? What if one of the named partners in X, Y, and Z, partner Z, for example, is given a 30-day suspension? It's not a disbarment, but it's time off. And it's time where partner Z can't practice law for 30 days. Must the firm go to the trouble of taking down the sign off the office building, changing the website, pulling all the advertising, redoing all the letterhead just because there's a 30-day suspension? Yes. Because during those 30 days, that lawyer is not eligible to practice law. So the name must come down. Here's an even tougher hypothetical. Sole practitioner. Lawyer L practices as L Law Firm and suffers from a suspension. What then becomes of the name of the firm? Well, the firm has no name because there is no firm during the suspension. So for the sole practitioner, even a short suspension is the death of the sole practitioner's law firm. What about a name where the firm tries to sound bigger and powerful, more bigger and powerful than it is? What if it's just Lawyer L? Lawyer L doesn't like the name L Law Firm, doesn't like the name Law Office of L, and decides to call the firm L and Partners or L and Associates. Is that a permissible name? And the answer is yes, if it's not false or misleading, which under these facts would mean yes, you can use the name L and Partners if L has a partner, at least one. L and Associates would be okay as long as L has associates. But you can't call yourself L and Associates if there are no associates, and can't call yourself L and Partner if there's no partner, because that would make the law firm name false and misleading. How about this? You call yourself L and Associate, and your associate quits. Do you have to change the name of your firm? Well, if you don't hurry up and hire another associate, then the answer is yes, because you can't maintain a law firm name that's false and misleading. That would be a violation of Rule 7.5 and arguably a violation of Rule 8.4. So you can't do that. So I hope this review of Rules 7.1 through 7.5 help you understand what a lawyer can and can't do when it comes to lawyer advertising. In our next lesson, we'll focus specifically on communications about a lawyer's services that meet that definition of solicitation. Specifically, in our next lesson, we'll be talking about Rule 7.3. Until then, may God continue to bless us all, and thank you for watching my lecture.